So today we'll do the introduction to RAW, and mostly we'll check, today is just introduction, whatever we'll cover on this semester, and then we'll be good to go. So whatever you are supposed to understand, we'll cover nature and purpose of RAW. What is the nature? This is the course, the content, the course of train. Then the second one is administrative law. Then number three, we will do the court system. Yes, those are the content that you know. Are you all in the WhatsApp group, the KC 2024 WhatsApp group? You are not up. You are in that group. Let me share you the link so that you can share with your friends. I have shared their materials, notes, and the past papers. You will share the link with them. So we will start with the nature and classification of law. And what are we supposed to know under this one? Mostly is the meaning of law, of the term law. So what can we say law is? Maybe. Yes. What can we say law is? Guidance, eh? Uh-huh. Someone else. So the law is a set of rules and guidance, or that governs our conduct. We can say is a set of rules that the meaning of law is a set of rules which guide our conduct in the society, and is enforceable by the state. And it's enforceable by the state via public agencies. So that is the meaning of the word law. Then there is nature. The nature of law. So there is several natures of law that we will go through. And the first one is natural law. The second one is a legal positivism. And the third one is legal realism. Then legal interpretivism. So that is how we do understand the law. We have said it's a set of rules and guidance that guides our conduct in the society. So what is a natural law? What is a natural law? What is a natural law? Maybe if I ask. These are rights inherited by our natural, the human nature. So there are rights, there is conduct that you usually do. So those are the natural law. So we can say it's opposite that certain rights are inherited by virtual human nature. So this law is, it has a divine nature. So you inherited it. When you were born, it was instilled to you by God. All right. So that is why we are calling it natural law. You just have it. Everyone have it. It's a human nature. Then we have the second one, this one, legal positivism. Positivism. So this is the product of authority. This one, product of authority. So it's like the parliament. Then we have the legal realism. The third one, huh? Legal realism. So this is the kind of rule that guide the judges. Mostly they are guided by public and social interest. Mostly like the courts. Then we have legal interpretivism. Legal interpretivism. So this refers, you can light, this refers to doctrine of the constitutional interpretation. Doctrine of the constitutional interpretation. Doctrine of interpretation of constitution. So from there, we check characteristic of laws. We have done meaning of law, then nature, can say characteristic. So by the meaning of law, how can you give a characteristic of law? Maybe. Yeah. So it's a set of rules. Somebody else? Yes. Yeah. Come again. It's dynamic. Then it's enforceable. It regulates human conduct. Rules are set to regulate people. Then they are enacted through certain procedures. Through certain procedures. So that is the characteristics of law. So after we do the characteristic, now we check the purpose of law. Purpose of law. What is the purpose of law or functions? Yes. Yes. Someone else? Yes. To maintain order. Mm-hmm. Someone else. So law they maintain order. Promotes, promotes peaceful coexistence. Promote peaceful coexistence and public order. And it prevents anarchy. So like mostly when there is demonstration, there is a lot of disorder. Is that right? Businesses are being destroyed. It's because there is no any rule that is being followed, or there is no any law that they are following. There is anarchy. Then it protects human rights. It protects human rights and provide remedies in the event of violation. Pro protects human rights and provide remedies in the event of violation. So that is where the Bill of Rights come. You have said if anything happen right now, you just go to court, to sue someone. So that is where you have a right. You have a right to be protected. Then resolve social conflicts. It resolves social conflicts. Resolves social conflicts. The other one promotes good governance. It promotes good governance. Promotes good governance, facilitates justice in the society. In the society. Facilitates justice in the society. Then the other one, the one she said, it maintain economic, that is economic and political stability. Economic and political stability. Because you know the rules that you are supposed to follow. So those are the purpose or functions of law. You may be asked as functions. Functions to purpose of law. So the law may be classified into several types of law, and we will check. We can write a classification of law. Classification of law. What are the classification of law? Yes? Yeah, public and private law, written and unwritten law. So classification of law. Number one is written and unwritten law. Number two is said public and private. Private law. Number three, criminal and civil law. Number four, principal and subsidiary. There is national or municipal, and international. Then number six, substantive procedural law. So this is the classification of law. We'll start with the written, written and unwritten law. So written is like the Constitution. The Constitution is already a written law. We can say these are types of law. These are types of law that are found in the informal documents. Informal document. They are found in formal document. So those ones are written. Then there is unwritten law. These are laws that are not contained. These are laws that are not contained in a formal document, and their existence must be proved. Must be proved. These are laws that are not found in a formal document, and their existence must be proved. So these are laws like, what kind of law that you know is not written? Yeah, African customary. Another Islamic law. So those are the African customary, the common law, the Islamic law, equity, and case law. Those one are laws that are not written. Then the second one is a public and private law. Public and private law. So we can refer public law is a branch of law, in which the state has a direct interest, has a direct interest. Is a branch of law in which the state has a direct interest. So this is like criminal law. This one, the state has an interest, then constitutional law and administrative. This administrative law. So those are type of public law. So we check a private law. You can say private law, they are law, it's a branch of law. It's a branch of law in which the state has no direct interest, in which the state has no direct interest. So that is the private law. Then we'll look the third one, the criminal and civil law. Criminal and civil law. Most of us, we know the criminal. We just feel like murder, those are criminal law. We can say these are rules and statutes. These are rules and statutes. These are rules and statutes that govern how people behave. Rules and statutes that govern how people behave. That govern how. So we can come again. These are statutes that defines, conduct, that defines conduct prohibited by the government, prohibited by the government, prohibited by the government, because it threatens and harms public safety. It is threatened because it is threatened and harm public safety, public safety and welfare, public safety and welfare. These are the cases of theft, cases of murder. They are classified under criminal law. Then we can check civil law. Civil law is a law that is concerned with private relations between members of a country, Just so. Between members of a country. So we can check the fourth one, principal and subsidiary law. Principal and subsidiary law. So you can say principal law governs people uniformly across the country. Principal law governs people across the country, whereas subsidiary law governs a category of people within the country. Governs a category of law within a country. So principal, it governs across. Then subsidiary, it governs a group or a category of people. This is like the Islamic law. Mostly in the banking, the Islam use a different banking method to the other people, other category. Then we can do the municipal and international law. Municipal and international law. Municipal. So you can say municipal law, they are applicable within a particular state, within a particular state or a country, So those are regulated within a country like Kenya. That is it's a municipal or national. You can say stroke national. Maybe you may be asking in an exam, national. This one, it's a national. Then this one is an international. So the other one, international, those are applicable internationally. They are law applicable internationally or between countries or states. Law applicable international between countries or states. So you can say this international law, you can say they originate, international law originate from number one, general principle of law, then international treaties, light general of law. Number two, can say international treaties. Number three, you can say conventions. Convention is like the summit that was here in Kenya for the climate change. They set rules. Then there is judicial decisions. Then there is customary international law. Customary international laws. Then the last one will be substantive and stroke procedural law. Substantive stroke procedural laws. We can say substantive laws are laws that governs how people behave, They are laws that govern how people behave. Then procedural law, these are laws that governs how a legal case flows, including steps to the process, including steps to process a case, including step to process a case. So these are the legal proceedings in the court. Those are the procedural because they have several readings. They have several readings to be administered. So that is the classification of laws. Now we check law and morality. Law and morality. Law and morality. Law and morality. What is the moral? We say he has a good or a bad moral. Yes? Virtues. Various. Behaviors. Someone else. So morality is the extent to which something is wrong or right. Extent. That is molarity. Molarity. So there are those behaviors. Someone may do a certain act and you term it, that is bad thing. Sindio? Maybe you may step on my feet and you just stay like that. You cannot say sorry. You see, you have a bad moral. So in fact, that question was asked in August 2009, and in other sitting, the current sitting, we'll do them in the next class. You should have printed a past paper. So you make sure you have a past paper. So we'll check similarity. Between law and morality. Law, we say they are set of rules. They are set of laws that guides people or a state. Then on morality, we have said is the extent to which something is right or wrong. So what kind of the similar thing that are both between law and morality? This is a very, very examinable question. So you can say both law and morality, they regulate human behavior. Both regulate human behavior. Both regulate human behavior. We can say law are a reflection of the moral standards of the society. Laws are a reflection of moral standard of the society at large, at large, at large. Before the laws are set, let's say the written laws, people had morals. Sindio? People had morals. So both regulate that one. Morality, the morality was there, knowing something is right or wrong. So we decided, how do we can come up with a law? We have written laws and written law, and the other types of laws. So number two, we can say they overlap and complement one another. They overlap and complement one another. You can say they complement. They complement one another. They complement one another. So those are the similarity. Both regulate human behavior and also they complement one another. Then we can check differences on law and morality. Differences between law and morality. You can say law is identical. Law is identical, while morality is relative. While morality is relative. The second one, law is enforceable. Law is enforceable by state, while morality is not enforceable by state. While morality is not enforceable by state. Can say law is enforceable. The other one is the custodians of law is the state. Custodian of law is the state. While morality is the religion. Well, or you can say just morality is enforceable, or the custodian of morality is religion. Is religion. The last one, law is usually limited to countries. Law, can say number 4 here. Law is limited to countries or states. States with no exemptions. Well, molarity cuts across the religion, while morality cuts across the religion. We can say there is some behavior that we have here. Even whenever you go, you'll still have the same behavior. So, maybe greetings. You'll say good morning, or you will greet someone by hand. Okay, other nation may not do that, but morality is across the religion. Whenever you perceive something is long or light, across the religion. When you go to Tanzania, when you go to Uganda, the same thing. So those are the differences of law and morality. So we can say the rule of law, the rule of law, the rule of law, the rule of law. So this was developed by DC on the basis of English legal system. And he said it comprises a distinct concept, which is absolute supremacy. So rule of law one is absolute. Whenever there is a election dispute, people go to courts, sindio? And whatever is determined there, they believe in that, sindio? What if there was not law? We say Azimio won, and there is no law. There will be anarchy, violation, there will be dispute. So we say it's supreme, supreme. It's very supreme. Then the other one is equality before law. Equality before the law. Then law is a manifestation of will of the people. Law is why do we say law is the manifestation of the will of the people? We have like Kenya, we have constitution. We follow the constitution. And anything that is in constitution, whether it's light or bad, we have to follow it because it was passed by the majority. And the majority, they show the will of the people, the will of the people. So what are the factors that undermine the rule of law? Factors that undermine the rule of the law. Any? Yes. Corruption. Anasema yako. Yes, someone else. ignorance of the law. So you can say corruption in the judiciary, corruption in the judiciary, corruption in the judiciary. Like now it's like there is a battle between the judiciary and executive. Sindio? They're saying there are so many judges who are corrupt. So that it's undermined the rule of the law because people now, may not trust the judiciary. Then there is disobedience of court orders. Of court orders. Being told you have to report to court on Monday. Then you say, I want to go. I want to go. So that one, it undermines the rule of law. It undermines the rule of law. Then lack of independency of the judiciary. Lack of independence. Lack of independency of the judiciary. Then selective prosecution. Selective prosecution. Hmm? Ama ni fair, mtu ameiba kuku, mwingine ameiba mamilioni kwa serikali, but wa kuku ndiye anafungwa. Is it fair? Si wote ni wezi. So if we do selective prosecution, we should prosecute fairly to the person who stole a chicken and also to the person who is corrupt. Then riots and demonstration that do not abide to the law. Riots and demonstration. That do not abide to the rule of law. The law of law. So those are the factors that undermine law. So we have done law of morality. So we are still under nature. Remember, nature and classification of law. That is the first topic. So we'll check sources of law. Sources of law. Sources. Sources of law. So what are the sources of law? Sources of law. So let's write sources of law. Ya kwanza ni constitution. The constitution. The second one is registration. Registration law or statutes. Number 3, delegated registration. Number 4 is statutes. So those are the sources of law. The constitution, the registration or statute, delegated legislation, statute of general application. Then there is common law, equity, case law, or precedent. The precedent, that is the laws made by the judges. Then African customary law and Islamic law. The Islamic law. So we start with the constitution. The constitution. The constitution. If you ask what is the constitution? Ambiwa kila wakati constitution of Kenya, constitution of Kenya. So it's the most authoritative instrument in the land. The most authoritative instrument in the lands. Those are the set of rules and guidelines that are compiled together for us or for people to be able to follow or to be guided by it. So, and mostly the constitution is the supreme. Is the supreme. So you can say a constitution as a supreme of law. Constitution as a supreme of law. Constitution as a supreme source of law. So you can say all the other laws derive their validity from the constitution, from the constitution. All the other laws derive their validity from the constitution. So you say the constitution binds all person and state organs. Constitution binds all the persons and state organs at both level of government, at both level of government, national and county. It binds all person and state organ at both level of government and national and county, maybe county government. Then the validity of the constitution, is not subject to challenge, before any court of any state or any state organ. The validity of the constitution is not subject to challenge before any court of or any state organ. Any law inconsistent with constitution, any law inconsistent with the constitution is null and void. To the extent it's null and void to the extent of its inconsistency. The constitution guarantee rights and freedom to all citizens. Rights and freedom to all citizens. So the constitution establishes the highest office. The constitution establishes the highest office in the land. The highest office in the land. That is the office of the president. The office of the president. So the second one is registration or statute. Registration or statute. Registration or statute. These are acts of parliament. These are acts of parliament and county assembly. These are acts of parliament and county assembly. So those are acts. So like the parliament of Kenya, it's made up of the Senate and the National Assembly. So the registration, those are what the members of parliament follow, the acts. The most unaonanga kwa constitution pia imeandikwa those acts of parliament. So iko hapo. So you can write the process of making a law from a bill. The process of making a law start from a bill. The process of making a law start from a bill. Then the bill is a draft of registration. The bill is a draft of registration. So we can write the types of bills. Government bill. This is drafted by Attorney General. Government bill, which is drafted by Attorney General. Then there is private member bill. Private member bill. This is introduced by a member of parliament in his capacity. So these are the bill you hear a given member of parliament has brought a bill to the floor. Then there is public bill. It's either a government bill or private member bill. A government bill or private member bill, which deals with the matters of public interest, which deals with the matters of public interest. It's a government bill or a private member bill, which deals with the matters of public interest. So that is like the government bill, it's BBI, and the finance bill also was a government bill. So whenever they come to the both houses, they are parliament acts. They are guided by parliament acts. So we can go to law making procedure, like a subheading, law making procedure. Law making procedure. Law making procedure. How is law made? Through parliament. Yeah. How is law made? Through parliament. They are act of parliament, and we have said they are made of a bill. The process of making law, we said, is from a bill, then is drafted to legislation. So you can say these procedures are the procedures of making law. Number one, the bill is published in the Kenya Gazette. The bill is published in the Kenya Gazette 14 days before introduction. 14 days before introduction. Then there is first reading. First reading, that is number two. First reading to the members of parliament. First reading to the members of parliament, and no debate taking place. And no debate taking place in the first reading. Then the other point, number three, second reading, after which debating take place. After which debating take place. And number four, committee stage, where the bill is referred either to a select committee or plenary. Committee stage, where the bill is referred, either to a select committee or plenary. You can say plenary refer to a committee of the whole house. So the select committee or a plenary. Plenary now is that committee. Yeah. Now they make critical analysis and consider contribution made during the debate. So we go to the other point, reporting stage, where the chairperson of the committee, tenders a report to the House. Tenders where the chairperson of the committee tenders a report to the House. Then the third reading is after which voting take place. Third reading voting take place. Then the other voting take place, that is the third reading. Then presidential assent within 21 days. Presidential assent within 21 days. So once the president has signed into law, so it's assented within 21 days from the date of presentation, then it's signed. And once it's signed, publication of the law into Kenya Gazette, Then we go to the other, number 9, publication, that is a commencement. The commencement date is expressed in the authority or given by the minister responsible. The commencement date is expressed in the authority or given by the minister. So when the president has given assent, it become a law. So kama kitu, there was this struggle about making charges on government services like ID, like marriage certificate. So once it's taken to the parliament and they debate over it, and two-thirds assent to all, give a positive comment on that bill, and the president has said it become a law. Just become a law. And that is what we are fighting now on the finance bill, because it was already passed. It was already passed. We can do process of presidential assent. Once he is given the bill, what does the president do? So, number 1, the process of presidential assent. Within 14 days, after receipt of the bill, the president then is required to assent the bill. So once the president is given the bill, he's supposed to take within 14 days to accept. If the president refers the bill back for reconsideration, Parliament may amend the bill in the light of the president's reservation, or pass the bill a second time without amendment. So within these 14 days, the president may not assent the bill. So maybe there is something that are needed to be rectified or to be done. He will refer it back. To the parliament, where it will be amended, or it will be passed the second time without amendment. And that is where there is in need of the independence of maybe registration and executive. So it may be amended or passed without amendment for the second time. So if Parliament that, are you done with that one? Are you done? So the point number 3, yeah, then number 3, under assent of the president, if Parliament amend the bill fully accommodating the president's reservation, if Parliament amend the bill fully accommodating the president's reservation, the appropriate speaker shall resubmit it to the president for assent. So if this bill has been taken back to the parliament by the president, and it's now amended to the reservation of the president. Now it's taken again to the president to be signed, or to president to give assent. So you can say, if parliament amend, parliament amend the bill fully to the president is taken back to the president for assent. So that is the process of lawmaking, the process of lawmaking, introduction of the bill, first reading, second reading, now this is where they make a recommendation. Then the bill is given a committee, they go through it, it's returned back to the parliament, there is voting. Once there is voting, it's taken to the president for assent. The president should assent it within the 14 days, within the 14 days. So number 4 for that, number 4, you can say parliament after the parliament consider the president reservation, after the parliament consider the president reservation, he may pass the, okay. I think that I have noted it. I have noted it somewhere. Where I said they may pass the bill the way it is, or they may decide to make the amendment. Then the appropriate speaker shall, within 7 days, resubmit it to the president, and the president shall, within 7 days, assent the bill. If the president does not assent to a bill, it's taken back to the period prescribed. So he's going forward and back something. I think I sent those notes on the group, so you'll also see them in the past papers. And that will be the end of today's class. We will do the other class. It's on Friday. Yeah.